So what he does when you point out these things is he attacks you. You guys know he likes to attack people personally, right? So just give me one more minute because we gotta have fun with it. He likes to go on Twitter. So he now says, well, first of all, he says that I'm sweating all the time. It's hot in here. Am I sweating now? No. All right. He doesn't sweat. He doesn't sweat because his pores are clogged from the spray tan that he used. Donald is not going to make America great. He's going to make America orange. The next thing, now, the other thing he says, he's always calling me Little Marco. And I don't think he's taller than me, he's like 6'2", which is why I don't understand why his hands are the size of someone who's 5'2". Have you seen his hands? They're like this. And you know what they say about men with small hands? You can't trust them. You can't trust them. You can't trust them.
Today on Legalese, we are discussing the Supreme Court decision in Vidal v. Elster, also known as the Trump too small case. Hey, greetings everybody, and welcome back once again to Legalese. As always, I'm your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me just remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalesepodcast.com. And if you want to stay up to date whenever I put out new content, because I don't just do videos on YouTube, I write a lot of articles on Substack, I post to alternative platforms, and if you want to get notifications for all of those things or some of those things, either way, all you have to do is head on over to legaleseshow.com, where you can subscribe to our newsletter. All right, well, today we have yet another Supreme Court wrap-up video for a case that I covered as part of my Supreme Court roundup this term. And we're going to be talking about the case of Vidal v. Elster. Now, it has been more than 7 years since Senator Marco Rubio, a Republican from Florida, would claim during a presidential debate that then candidate Donald Trump had small hands. Now, back in June of 2023, the justices agreed to weigh in on a trademark dispute that would arise indirectly from that comment, and this, of course, is the case of Vidal v. Elster, and we have talked about this in past videos, which I will link to on the show notes page if you want the background for this case, but specifically, we're talking about the case dealing with Steve Elster and his efforts to register the phrase Trump too small so that he could print it on and sell it on t-shirts bearing that phrase. Now, Elster contended that the phrase was intended to convey that some features of President Trump and his policies are diminutive. But the Patent and Trademark Office rejected Elster's application. Now, they would rely on a federal trademark law under Section 2C of the Lanham Act that prohibits the registration of a trademark that uses the name of another living person without that individual's permission. Now, the PTO, which is the Patent and Trademark Office, Trial and Appeal Board, would uphold the initial PTO decision, but he would appeal the case to the Court of Appeals for the Federal Circuit, and they would reverse the holding. Now, in the Federal Circuit Court, it ruled that relying on Section 2C to prohibit Elster from registering the Trump too small phrase would violate the First Amendment. Now, when it comes to trademarks, the Court of Appeals would explain that the government does not have an interest in restricting speech critical of government officials or public figures. Now, the Biden administration came to the Supreme Court in January asking the justices to review the Federal Circuit's decision. And U.S. Solicitor General Elizabeth Prelogar argued both that the lower court's ruling is wrong and that the Supreme Court normally grants review when a federal appeals court strikes down a federal statute. Now, the court, yesterday now, on Thursday, unanimously rejected an attempt to force the Patent and Trademark Office to accept the registration of Trump Too Small as a trademark for t-shirts mocking the former president. Now, Steve Elster had argued that the provision in the Lanham Act that directs the PTO to refuse to register any mark that identifies a particular living individual violated his First Amendment rights. Now, although the justices did splinter sharply on their reasoning, all of them agreed that the First Amendment permits the PTO to refuse to register this mark. And furthermore, all nine justices would agree on the basic framework of the analysis, which appears early in the principal opinion, which was written by Justice Clarence Thomas. Now, writing in that part of his opinion for six justices, which were the six more conservative justices, so we have Kagan, Sotomayor, and Ketanji Brown Jackson not joining him here, Thomas would explain that the restriction is viewpoint neutral, but not content neutral. And as he observed, the justices have twice concluded that trademark restrictions that discriminate based on viewpoint violate the First Amendment. Now, the earlier restrictions were viewpoint based because they prohibited trademarks based only on one viewpoint while permitting trademarks based on other viewpoints. But the ban here, by contrast, Thomas argues, is viewpoint neutral. And Thomas pointed out that the PTO's refusal of trademarks such as Welcome President Biden, I Stump for Trump, and Obama Pajama are rejections that have doubtlessly disappointed a broad range of political viewpoints in the past. Now, having said that, Thomas explained that the restriction is still content-based because it implements a ban based on the content of the trademark. So turning to his majority opinion, Thomas says, the names clause turns on the content of the proposed trademark, whether it contains a person's name. If the trademark does contain a person's name, and the registrant lacks that person's consent, then the names clause prohibits registration. And so, acknowledging that the justices in Vidal v. Elster were, for the first time, considering the constitutionality of a content-based but viewpoint-neutral trademark registration, Thomas would turn to offering his reasons for approving the statute. And specifically, Thomas rested his decision on an account of the history and tradition of content-based trademark restrictions, a discussion that generally showed a long tradition of preventing any individual from using a trademark to prevent others from using their own names to identify goods in commerce. And for Thomas, that discussion was enough to establish that, again turning to the opinion, the names clause has a deep root in our legal tradition, and accordingly he concluded the names clause is of a piece with a common law tradition regarding the trademark of names, and therefore we see no reason to disturb this long-standing tradition which supports the restriction of the use of another's name in a trademark. Now, in a separate opinion that shows much less devotion to a historical approach, First Justice Brett Kavanaugh, joined by Chief Justice John Roberts, would join most of Thomas's opinion, but Kavanaugh wrote a brief concurrence explaining that the two of them were open to the possibility that a viewpoint-neutral, content-based trademark restriction might well be constitutional, even absent such historical pedigree. Now, second, and perhaps most pointedly, Justice Amy Coney Barrett, who was joined in large part, though not entirely, by Justices Sotomayor, Kagan, and Jackson, wrote to explain her position that it was wrong twice over to argue that history and tradition alone can settle the constitutionality of the names clause. Now, her first point is that the majority's history was wrong. Now, turning to her majority opinion, Justice Barrett wrote that the court's evidence, drawn loosely from related cases, does not establish a historical analog for the names clause. Her second point was that the majority was wrong to rely exclusively on history. She faulted the majority for its failure to explain why hunting for historical forebears is the right way to analyze the constitutional question. Now, Justice Barrett preferred instead to adopt more of a doctrinal First Amendment rule reflecting the relationship between contest based trademark restrictions and free speech. Specifically, Barrett's test would permit any restrictions that are, in her words, reasonable in light of the trademark system's purpose of facilitating source identification. And she would say, as applied to the names clause at issue, Barrett would reason that Congress's general determination about the use of names and trademarks was a categorical judgment that Congress is entitled to make, particularly where heightened scrutiny does not apply. Now, the most critical of these separate opinions came from Justice Sotomayor, who would be joined by Justices Kagan and Jackson. Now, she started with a very stern criticism of the majority's historical approach, characterizing Thomas's selection of the authorities that he discusses as the equivalent of entering a crowded cocktail party and looking over everyone's head to find your friends. Now, Sotomayor pointed to the confusion that the lower courts have had over applying the similar analysis that Thomas offered in the landmark New York State Rifle and Pistol Association versus Bruin case. And on the merits, Justice Sotomayor found the names clause permissible because it simply conditions a government benefit, which is a trademark registration, on the content of the speech. She explains that registration only confers additional benefits on trademark holders, and that refusal to register does nothing to prevent Elster from speaking or selling objects, including the mark. Accordingly, she found the provision well within the court's First Amendment precedents. Now, it was clear from the briefing and arguments that this case would divide the justices, as earlier cases considering the relationship between the First Amendment and trademark law have traditionally done. Now, my personal guess here is that it will not be long before we see yet another challenge to a different provision of the Lanham Act, and that when that comes, the justices will be just as divided as they were on Thursday. Well, anyways, that is really all I have for you guys here today. I will be back tomorrow with a new video about another case from my Supreme Court roundup, Garland v. Cargill. That is a big case about the bump stock ban case, so be looking out for that. But in the meantime, just remember, if you could please take a moment and do all of those things that help to trigger Al Gore's rhythm, I would greatly appreciate it. If you liked the video, hit that like button. If you disliked it, you can hit the dislike button. Subscribe to the channel so you always get updates when I put out new videos. And definitely leave me a comment and let me know what you thought about this video or the topic we discussed, or just whatever thoughts you may have. So, until next time, this has been Bob for Legalese, talking about Vidal v. Elster and the Trump 2 small case. And of course, as always, Carthago delenda est.